Good morning, everybody. Thank you for joining us for the July Enterprise Risk Management Toolbox webinar. A couple of housekeeping notes before we get started. If you've dialed in by phone but haven't logged in by web and you'd like to see the slides that are being shown during the presentation, please point your web browser to readytalk.com. In the box where it says Participant Join a Meeting, enter the same access code that you used to join the call, 987-9821. We're leaving the phone lines open, so please stay aware of the level of background noise in your area, and if it starts to get noisy, please put your phone on mute. If your phone doesn't have a mute button, you can use the ReadyTalk controls, which are *6 to mute and *7 to unmute. If you're called away from your phone, please don't put your phone on hold, because that will cause your hold music to be transmitted to everybody else on the call. You can simply hang up, dial back in when you're available, and it will not disrupt the call. With that, I will hand the controls over to our presenters. Stephanie and please, good morning.
Hi, this is Stephanie Leiter. Leslie Van Houten and I share the disability advice practice here at the Office of General Counsel's Labor, Employment, and Benefits Group. And probably a day doesn't go by where we're not struggling with some challenging disability question that we've gotten from the campus or from the Office of the President. Just to start off, Leslie just found some interesting statistics. Apparently, the Department of Labor in 2011 said that 50 million Americans had a disability. And we've also heard a quote of 20% of the workforce is disabled. Now, we know that a lot of those people manage to work and never request an accommodation, but more and more people are understanding their rights and they're coming forward and requesting accommodations. And as you know, if they don't have to use magic words to request an accommodation. If the employer becomes aware of their need for some assistance in order to perform the essential functions of the job, the employer really needs to initiate what we call the interactive process to talk about what accommodations might be effective to enable the person to perform the essential functions. So today what we're going to cover are significant changes in the Fair Employment and Housing Act regulations that relate to disability accommodation, and also some recent cases that involve disability discrimination and issues about accommodating employees with disabilities. So first we're going to talk about the laws. Oh, we need to be advancing the slides.
Double-click on it.
So California lawmakers have been busy, and on this slide, slide 4, we're focusing on some of the new laws and regulations that have come out in the area of accommodation. There are many other laws that affect employers, but this slide really is focusing on accommodations. And in October 2012, Governor Brown signed California's Workplace Religious Freedom Act, which amended the Fair Employment and Housing Act, effective January 1, 2013. We're not going to spend any time on that today, but if you're interested in religious accommodation, Leslie's become our resident expert on that, and she could do a training on just that issue. And then in December 2012, just before they disappeared, the Fair Employment and Housing Commission, which is now defunct, released new, why is that beeping?
I'm getting a little background noise. I'm going to mute one line here.
Okay. So in December 2012, they released new Fair Employment and Housing Act regulations regarding pregnancy disability and disability accommodation. And we are just going to focus on the disability accommodation ones. The pregnancy disability ones are also quite interesting. They cover more than accommodation, but they do really focus a large part on how we have to accommodate people who are disabled by pregnancy. And that's a whole other interesting topic, and we could spend an hour or more on that too. But today we're going to focus on disability accommodation. And we are going to highlight, or Leslie, I'm going to turn to Leslie now. She's going to start us out on the regulatory side.
Good morning, everyone, and thank you for tuning in. Indeed, the new disability regulations that issued January 1 had some surprises, and we're going to tell you about the two big surprises. And then a lot of the rest of the regulations were just codifying the law as it was evolving, and Stephanie and I were pleased to note that our advice was consistent with the way the disability regulations came out. But right now, we're going to focus on two of the most significant changes that were a bit surprising. The first one that I'm going to talk about is the greater limitation on our right as an employer to have information relating to an employee's disability and limitations. We always thought that our disability managers and coordinators and voc rehab counselors, those people who work directly with the employee and the employee's health care provider, could have health-related information and know about, if necessary, the diagnosis, things that we would not pass on to the supervisors or to the department, but which the vocational rehab counselor or the disability coordinator needed to help make a reasonable accommodation. Well, these regulations tell us basically we can have very little information, and they also appear to limit our ability in certain circumstances to get limitations about the employees as a result of the employee's disability. So let me walk you through these. This is a little dense, so I am going to do a lot of information, or a lot of reading about this information. So it's, the first principle is when the disability or need for reasonable accommodation is not obvious, the university may ask for reasonable medical documentation. So this seems to imply that if an employee has an obvious disability, that we can't ask. But that itself makes no sense, because oftentimes the accommodations that the employee needs, even one with an obvious disability, are not obvious. So for example, there's been a situation where an employee who has an obvious disability, is in a wheelchair, has been accommodated the obvious way, but needed additional accommodations that were not obvious. And so the regulations don't seem to take that into account, but I do think it's going to be reasonable for us to require limitations from the employee's health care provider if the need for the accommodation is not obvious, even if the disability is obvious. So what we cannot get is we can no longer require the diagnosis or make inquiries about the underlying medical condition. And this actually sent shockwaves. I was at a national conference recently, and they were talking about accommodating disabled faculty, and I just had to stand up and say, you know, in California you can't have the diagnosis. And it was sort of shockwaves went through the whole room, because they were focusing on, we don't even know yet whether this faculty member is disabled. We need more information. We need a diagnosis. We're primarily going to jump right by that here in California. So this is what the new regulations say about our ability to get limitations. Where necessary to advance the interactive process, reasonable medical documentation may include a description of a physical or mental limitations that affect a major life activity that must be met to accommodate the employee. Where necessary. Well, I think that as your disability managers go through the interactive process, they should always think about why they need the limitations and document that as part of their internal notes, because we do need the limitations. We do need to know what the employee's physical and mental limitations are, so that we can do a proper accommodation.
And the law definitely requires that we tailor the accommodation to that particular employee's situation. So you really want to know what's really happening with that employee, how they really are limited.
So I'm going to say almost always we are going to need to know what the limitations are, unless the limitations are related to the obvious physical disability. So the next question is, what do the regulators think is reasonable medical documentation? So again, repeating, where the existence of a disability and or the need for reasonable accommodation is not obvious, an employer or other covered entity may require an applicant or an employee to obtain and provide reasonable medical documentation from a healthcare provider that sets forth the following information. The name and the credentials of the healthcare provider, which establish that the individual falls within the meaning of the healthcare provider. That the employer, by the way, and this is maybe the only way that you'll have any idea of what the disability is, by knowing the specialty of the particular healthcare provider. That the employee or applicant has a mental or physical condition that limits a major life activity, or a medical condition, and I'm going to come back to that, and a description of why the employer or applicant needs a reasonable accommodation. I'm going to stop there. Let's talk. We all know about a disability is a physical or mental condition that limits a major life activity. But a medical condition is narrowly defined in California law. It has to do with cancer or genetic condition, and it does not need to limit a major life activity. So that's a new emphasis that the regulators are putting on medical condition. We may have people come forward with those two conditions, cancer or cancer-related, and a genetic condition, and there's no requirement in order to get an accommodation that those conditions limit their major life activity. Okay, so why do they need a reasonable accommodation? To have equal opportunity to participate in the application process and be considered for the job for applicants, or to perform the employee's job duties, or to enjoy equal benefits and privileges of employment compared to non-disabled employees. Most of our practice focuses not on applicants but on employees, and most of our practice focuses on accommodating them to do the essential job functions. So what does it mean to enjoy equal benefits and privileges of employment compared to non-disabled employees? Well, a classic example is the lunch or break room. The lunch or break room, if it's inaccessible or unusable by the disabled employee, that employee is denied a benefit that other non-disabled employees have, which is access to that break or lunchroom. And so we need to make that room accessible to our disabled employee. That's just one example. I would say that attending meetings and being able to understand and follow what's going on in an office meeting would be another example of the benefits and privileges of employment. So this is again fascinating. The employer or the covered entity shall not ask for unrelated documentation, and this is amazing to me, including in most circumstances an applicant's or employee's complete medical records, because these records may contain information unrelated to the need for accommodation. Well, even before these regulations came out, I cannot imagine a scenario when we would need, nor should we ever ask for, the complete medical records. So going on to the next slide, one of the things that is very interesting here, and at least they put some parameters on it, for medical accommodations lasting beyond 1 year, the university may ask for medical documentation supporting the need for continued reasonable accommodation every year. So that's important, and it's something we should use. Well, what is insufficient medical documentation? If it does not specify the existence of a covered disability, so again, they don't have to tell us what the disability is, but they need to say, my patient is disabled. If it does not explain the need for reasonable accommodation, well, what the heck does that mean? Is it sufficient if it says, my patient Leslie has a disability and she needs a reasonable accommodation? I hope not. We don't know. It's going to take a while through the courts and through legislation to figure out what this means. But I like the word explain the need for reasonable accommodation. I would push back on that. We recommend that you push back on that and ask the healthcare provider to explain why the employee needs a reasonable accommodation. And again, this limitation, where relevant, provide functional limitations. Again, we are going to advise that they're almost always relevant. And this is my favorite. Remember, we don't get to know what the diagnosis is. We don't get to know anything other than maybe, if we're lucky, the limitations. But it says if the healthcare provider does not have the expertise to confirm the employee's disability or need for reasonable accommodation. Well, how the heck are we going to know if we don't know what the disability is? The only condition I can think, or the only example that comes to mind, and this actually happened down at one of the medical centers, apparently one of our more enterprising employees stole script from OBGYN and recommended that he be off work because of a broken leg. Now, that might be a case where we could tell on the face that the healthcare provider does not have the expertise, but generally this is not going to be all that useful. And then finally, where other objective factors indicate that the information provided is not credible or that the information is fraudulent. We've rarely seen that, but this is available to us if that happens. Please note, this is another new part of the regulation that is going to be very difficult to implement. If the medical information is not sufficient, we must still provide a reasonable accommodation supported by the information we have as of that date.
That's really going to be a challenge.
It is.
The disability managers spend a lot of time figuring out the appropriate accommodation, and if they do that based on just what we have so far, and then you have to rethink it when you get further information, it's really going to be a challenge. And as Leslie pointed out, a lot of how these things are going to play out is really still a mystery to us. We don't have case law yet, and we're trying to advise in a conservative way to hope that we don't become the case law, but it's still, we're kind of feeling our way. Turning to the next slide. So one of the themes throughout these new regulations is that they're being specific in the regulations about things that have developed in the case law. And one of the areas is they're listing more things, more examples of what could be a reasonable accommodation. And when it gets to assistive animals, they went into a lot of detail. And we think this is important because we think given the amount of detail, we're going to see more requests for employees who want to have animals in the workplace. And there are all sorts of challenges presented by that. But we usually think of guide dogs when we think of assistive animals. But these regs made clear that when they talk about assistive animals, they come in various types. And typically we talk about dogs, but other types of animals can provide these types of services to the disabled. So guide dogs are one example, and that's what I think we're typically used to seeing and hearing about. These animals are trained to guide the blind or the visually impaired, and typically dogs, but it's possible that they could be other animals. Signal dogs or other specially trained animals are ones that are trained to alert a deaf or hearing impaired person to different types of sounds. Service dogs or other specially trained animals are trained to serve the requirements of the disabled person, and so it really could vary depending on the disability that the person has. And then support or comfort dogs or other animals. These are animals that are there to provide support to persons with disabilities, including people with traumatic brain injury or mental disabilities like depression, but I think we're going to see some creative requests from people that want a support or a comfort animal of different kinds. I know watching NACU messages over the years, on the student side, there have been some really creative requests for different types of animals that are going to serve the comfort role, and we could start seeing that on the employee side. Not many questions have reached us yet, but I think we're on the precipice of that. So the regulation sets some minimum standards that these animals have to meet in order for the employer to be required to allow them in the workplace. So they must be free from offensive odors, and they must display appropriate behavior for the workplace environment. They can't endanger the health and safety of others or of another individual with a disability. And I think this is going to be really important to us because we may have one employee that wants to bring a dog, for example, in as a service animal, and another employee has a severe allergy and can't be around the dog. So we're going to be dealing with competing disabilities and accommodations and have to sort out how everybody can be accommodated, and I think that'll be a challenge. They also must be trained to provide assistance for that particular employee's disability.
And that's going to be really interesting with comfort animals because as I understand it, there's no training for a comfort animal. So I'm not quite sure how that one is going to play out.
Yeah, and whether they can just have the animal in their office or whether if they have regular meetings with other employees, whether the animal's going to need to be in those meetings. It's going to be really interesting to sort this out. And everything's going to have to be case by case. We're going to have to hear the specific examples, the type of animal, what problems it's presenting. So moving to the next slide, what can we require when an assistive animal is allowed as a reasonable accommodation? So up front, there should be a letter from the employee's healthcare provider stating that the employee has a disability and why the employee requires the presence of that animal in the workplace. For example, why the presence of the animal is necessary to help the employee perform the essential functions of his or her position. We can also require confirmation that the animal meets the minimal standards of cleanliness, appropriate behavior, and purpose. But the regulations specifically state that this confirmation can be based on information provided by the employee. So I don't know if we're going to get, if that's going to be much of a hurdle. It also says that the employer may challenge whether the animal meets those minimal standards in the first 2 work weeks that the animal is in the workplace. And the challenge has to be based on objective evidence of offensive or disruptive behavior. Now, we're a little worried that that ability to challenge is limited to the first 2 work weeks. I could see an animal being on good behavior and everything going fine for 2 weeks, and then suddenly it's a problem, and the regulations appear to end our ability to challenge after those 2 weeks have passed. So that could be problematic. They do say that the employer may require yearly certifications of the employee's continued need for the animal. So that's one thing that's helpful. But this is, again, kind of uncharted territory, and we're going to feel our way carefully.
We did learn from one webinar from one of the directors of the DFEH that there will be further revisions to these assistive animals section, in part because they didn't take into consideration other laws that prohibit animals in places like where food is prepared and things like that. So
yeah, how many years did they work on these regs?
I don't know. You'd think they would have figured this out.
Yeah. Okay, so now we're going to turn to some interesting cases that have come up in the last couple of years.
I'm going to start off with what is really a landmark case in California that applies. It's in the pregnancy disability or pregnancy discrimination realm, but it applies to all of these cases. And it's Harris versus City of Santa Monica. It is a California Supreme Court case, and it changed the test for how to handle a case where there is evidence of both an unlawful motive and lawful motives for an adverse employment action. Those are called mixed motive cases. So I've got a good reason why I terminated you, and there's evidence that I may have had an unlawful reason. So the case came out and held that where the plaintiff's protected status is a significant motivating factor, then there will be a finding of liability. But if the employee's protected status was not a significant motivating factor, the employee may prevail in one way, and I'll tell you about that shortly, but she cannot be reinstated and she's not entitled to economic damages. So just how can an employee who establishes that the employer establishes that there were good reasons for the termination, and the employee establishes, yeah, but there was also this unlawful motive, what does that employee entitled to if it's not a significant motivating factor? She can be entitled to the big ticket item here, attorney's fees, plus declaratory or injunctive relief. So we think so the good news is it's going to be harder for plaintiffs to win these cases, but it's going to be nonetheless mean that plaintiffs' lawyers may take these because they still could recover their attorney's fees for the if they do establish that there was an unlawful motive. And I'm just going to briefly give you the facts in Harris because they were very, very interesting. Ms. Harris was a probationary bus driver for the City of Santa Monica. During the time that she was in training, she had an avoidable accident. Nonetheless, she passed her training period and became a probationary bus driver. And she had yet another avoidable accident and 2 attendance-related issues. On the very day that they were going to get together and see who was going to get off probation and who was not, her boss stopped her and told her to tuck in her shirt. She confessed that she was pregnant, and he made one of those sort of inane but slightly inappropriate remarks. He said, "Wow, well, what are you going to do? How far along are you?"
We've certainly heard worse.
Yeah, we've heard a lot worse. Then they go to a meeting and they decide, not surprisingly, any bus driver who has 2 avoidable accidents and 2 absenteeism in this short period of time is not a good candidate for a career position. And they terminated her. Surprisingly enough, the jury found that there was discrimination based on her pregnancy by the boss's remarks and the timing of the probationary release. But in the end, it turned out not to be a substantial motivating factor or significant motivating factor. It was a factor. So in the end, there was a finding that the City of Santa Monica, in particular I'd say the supervisor, had an unlawful motive, but they also had substantial other factors, her 2 avoidable accidents and her early record of absenteeism, as good grounds to not promote her to a career position. But I guess one of the lessons I take from these and every other case that I've seen that has to do with pregnancy is it doesn't take very much for a jury to just determine that there is discrimination based on pregnancy, however slight the factual or however weak the case is.
So we wanted to talk about Harris because the same sort of analysis would apply in a mixed motive case where the employee's protected status was just disabled, not disabled by pregnancy, but just regular, any other kind of disability. And it's kind of a new territory that California is in, so we wanted to just start off with that. The second case we want to talk about is Johnson versus Board of Trustees. This is a Ninth Circuit case, and it actually arose in Idaho. But the Ninth Circuit includes California, so we want to be conscious of it. This is a case of a plaintiff who was a special education teacher. And in Idaho, they were required to have a valid teaching certificate, and it came up for renewal every 5 years. And in order to renew it, they had to have a certain number of hours of training, including a certain number of those hours that were actually college credit courses that the teacher had to pay for. Well, Johnson had a recurring problem with depression, and she had her certificate that was going from September 2002 to September 2007. In the summer of 2007, just as she was about to finish the training she needed to get her recertification, she suffered a major bout of depression, and she didn't end up getting her hours. So she went to the school, and she asked if they would petition, if they would ask the Board of Education to apply for provisional authorization, essentially to let her be excused from that requirement and to be provisionally authorized to work until she got the certification. And the board denied the request. They said, look, you had 5 years to get those hours, and you waited to the last minute, which I'm sure so many people do. So they weren't sympathetic. And they also pointed out that really that option to request provisional authorization is one that exists for the schools, and it's for situations where the school has no options to have a certified teacher, and they have people who are qualified to do the teaching but don't yet have that certification, so the schools can ask to have permission to use the teachers that don't yet have the formal certification but are qualified. And they said in this instance, we've got a couple of teachers who are certified and could do the job that Johnson would be doing. So there's really no need for the school or the board to petition for this provisional authorization. So a lot of the cases focused on, basically then they denied her that. They ultimately terminated her contract and terminated her employment, and she sued. So the case focuses on the question of who is a qualified individual with a disability, and that's an essential question because only people who meet that standard are deserving of the protection of the disability statute. So the court said that there's really a two-step inquiry when you're deciding whether someone is a qualified individual with a disability. The first step is, do they have the kind of skills, experience, education, licensure that is needed to do the job? And the second step is whether the employee can perform the essential functions of the job with or without reasonable accommodation. And the court said, when you're talking about the first prong, the skills, experience, education, licensing, there's no question of reasonable accommodation that comes up. And she had been saying they should accommodate her by giving her more time to get the certification or letting her teach without it. And the court said, no, with that first prong, the employee needs to come with that experience, education, license, et cetera. There's no obligation on the part of the employer to help them qualify if they don't already have that. So we thought that was a really interesting case and not very characteristic of the Ninth Circuit because it's usually a very pro-employee circuit. But it's an interesting point.
One of the things we think is interesting about this case is that you have to keep in mind that if you would give a non-disabled person a similar opportunity to get the certification, then you would have to do it for the disabled person. You couldn't treat her worse. But in this case, the school board never used this provisional certification process for a situation like Ms. Johnson's. Rather, they used it only after they tried to find a qualified person, and then they would give somebody this provisional certification to teach for a year. But it's always really important to remember that we have to treat our disabled employees as we would our other employees.
Yeah, when Leslie and I are given advice, we often say, the case law or the regulations say you can do X, but we also want to know, have you treated any non-disabled employees in the way that this employee is requesting? Because that's going to be a bad fact if you deny the disabled person the request that's being made. So that's a really good point. We always have to look a little bit more carefully at the actual facts and what the practice has been at the relevant location. The other thing I want to highlight is that if the employee happens to be somebody who's returning from military leave and they have a disability because of their injury while they were on military leave, USERRA, which is the law that governs federal military leave, is very generous, and it actually says that if the employee is disabled or returns from military leave without qualifications, the employer does have an affirmative obligation to reasonably accommodate that and help them gather the training they need to to develop the skills that are needed, or even to obtain the requisite licensure or certificate. So, while this decision is very pro-employer, we want to be very careful about how it's applied in our workplaces. The next case.
This case is one that got a ton of press, and all the management lawyers were very, very excited about it, but Stephanie and I view this case with great caution. I think actually it was a bad case of lawyering. This case is called Lawler versus Mont Blanc of North America, and many of you may know those Mont Blanc pens as being those fancy, expensive pens that apparently, reading the case, they sell other things. Ms. Lawler was the store manager. She had worked for the employer for about 8 or 9 years. Mont Blanc does most of its business, about 70% of its business during the holiday season from Thanksgiving through Christmas. And during that holiday season, the store manager ends up working 7 days a week, 10 hours a day, about 70 hours a week, and the store manager has to be on site. This store was a small store, and I believe Ms. Lawler had 3 other people reporting to her. In October, she was diagnosed with a kind of arthritis, and her doctor recommended that she work part-time. Shortly thereafter, she had an injury related to her arthritis where she tripped and hurt herself, and her doctor wanted her placed off work from October through January 5th. There was some back and forth with the HR people. It doesn't look like they ever granted her the part-time leave, let alone the full-time leave, and in fact, they terminated her in October. Sounds like a slam-dunk case to me, but in fact, on summary judgment, the employer won. In other words, it was litigated only as a discrimination case. The only issue, well, there are a couple of other issues, but not the ones that should have been litigated. The only issue from a disability standpoint was she discriminated against because of her disability. On the pure discrimination issue, the court held no. It was clear she could not perform her essential functions of the job, and the court went on to use this language that I have on the slide, which, as far as I can see, isn't based on the facts. It said her termination was not discriminatory because Lawler could not do the essential functions of the position, and it was not clear when or if she would be able to do them. Actually, there was nothing from the doctor that said she may never be able to do her job duties. There were facts that were developed afterwards because she was out for well over a year, didn't apply for a job, and couldn't work. But at the time they terminated, the doctor's note said she should be off leave on leave until January 5th, sounding like a return to work date to me. But from that, the court said it was not clear when or if she would be able to work. Well, what was the matter with the way this case was handled? What was the matter was they didn't plead a failure to accommodate, and they didn't plead a failure to do the interactive process, both violations in California law. because if they couldn't have accommodated her in her own job, and it sounds like she couldn't be, then Mont Blanc would have had an obligation to look for another job for her, which it did neither one of those things. It didn't do the interactive process, and it didn't look for another job. So while you may read great things about this case, I think, as I said, it's not as wonderful as it could be, because with good lawyering, they could have pled 2 other seemingly winning causes of action. And the court does make note of that. It doesn't talk about the merits, but it does make note that they failed to do that.
We also wondered why there was no mention of family and medical leave in the case. Apparently, the employee didn't ask for that, because that would have been job-protected leave.
Well, she asked for leave, and she doesn't have to use the magic word.
Yeah,
so
but they must not have pled a denial of
family,
FMLA or
yeah.
sick leave. So, yeah, this is one of the cases where people are like so excited and left in or off at having to say, but wait a minute.
Yeah, wait a minute. This case is not as good as it sounds. Okay, here's actually the next case, Stamper versus Providence St. Vincent Medical Center. This is actually a very good case. And it came up from the Ninth Circuit, and you know how the Ninth Circuit is often a little dicey. Really, it's been interesting to see that the 3 cases that we're talking about have been pro-employer. So let me read. They've been pro-employer.
Pro-employer, yes, sorry about that.
I love the way the case starts out, and I'm going to read it to you. This case tests the limit of an employer's attendance policy. Just how essential is showing up for work on a predictable basis? ? In the case of a neonatal intensive care nurse, we conclude that attendance really is essential. Yay! We have a lot of attendance cases, we know a lot of disability managers are on the line, as they'll tell you this becomes one of our big issues. But let me tell you about everything that Providence Hospital did to accommodate Ms. Stamper. Ms. Stamper had worked for them part-time for about 9 years. Providence had a policy that allowed people to have 5 unanticipated absences in a 12-month rolling period. Ms. Stamper had fibromyalgia, although it appears that the employer did not know that initially. She started out and she was violating the attendance policy because she would end up having more than 5 unplanned absences. Remember, too, she's only working part-time. And eventually, they wrote her up for it. It must have been then that she told them about her fibromyalgia, because they entered into the interactive process and they gave her a wonderful accommodation. Her accommodation was that her first accommodation was that if she couldn't make it because she was having a bad day, she could call up, let them know, and take another shift that week, and she wasn't even required to find a replacement for herself. But that didn't work. She continued to exceed the absenteeism policy, and so they brought her in, had another interactive process, and this time they said, she didn't have to work 2 back-to-back shifts. She could have time off in between her shifts, and that still didn't work. She continued, and throughout this, by the way, she had other approved absences, which didn't count against this, including a couple of medical leaves of absence. Eventually, she once again exceeded the 5 unplanned absences in a rolling 12-month period. In fact, she had 7. About that time, her part-time job was going to disappear, and she was offered another position, or she said she could terminate. She responded, haven't we heard this before, by making a few inappropriate comments in the presence of patients, and she got 2 more corrective absences, and she was scheduled to discuss her attendance issues with management at a meeting which she characteristically did not show up for, and she was eventually fired. She sued. She said the accommodation she should have been given is an absolute pass from being held to the employer's attendance policy. The court, in this case, examined her job, talked a great deal about what goes on in the neonatal nursery, how critical the patients are, how important it is to have trained people, how not every nurse can work in the intensive care nursery. You have to be specially trained, and so there wasn't a large body of people to pull from. And they said her request is absolutely unreasonable, and the employer did not have to provide her unlimited absences. A great victory. I think what's really important to take away from this are a couple of things. Number one, they did try very hard to accommodate her. In fact, the court commented that they may have done more than they had to, but I can't help but think that it put the hospital in really good stead, that they had tried to really work with her and make this work. And then secondly, they examined the kind of job she had. It is really clear that certain jobs do not necessarily require presence or do not require presence all the time, and you have to be mindful of that. The other lesson in this day and age of Skype and things like that is certain jobs that may have required presence before may no longer require physical presence. So those all are important things that you have to be considered. You have to consider. So then the last point I want to make is I was looking online about this case, and there's a California appellate blog by a law school professor, thankfully not ours, who has too much time on his hands. And I think this may be where plaintiffs' lawyers go with these attendance accommodation cases in the future. He said that he thought that in this case the court got it right because it looked at the kind of work Ms. Stamper did, but it did not look at what he thinks is another important factor, the size of the workforce. He says that depending on how big the workforce is, there may be an ability to cover more unexcused absences than Ms. Stamper was allowed. He thought Providence probably had a small enough workforce that their rule was reasonable, but if he looked at a really big neonatal nursery that they might have with a large number of nurses, he thought that that might permit that kind of accommodation. And he pointed to family and medical leave as an example of statutory right to take a certain amount of unpredictable, unscheduled absences without any kind of punishment. So I'm not thrilled about this article, but I think that we may see this wave of litigation for a larger institution like the University of California, this theory being advocated. Next case. Oh, is Will, still mine. This case is an old case, but I really think it's important to bring it up. By old, 2011. Those of us who practice in the Ninth Circuit have been worried a lot about three cases that came out of the Ninth Circuit: Humphreys versus Memorial Hospital, Dark versus Clark County, and Gambini versus Total Renal Care. All of those cases held that an employer could not punish discipline if the discipline was caused by the disability. And we had no idea how the California courts would go. So this is a case, Wells versus Superior Court, that happened, as I said, that came out in 2011. And we have learned that in California, an employer can discipline for conduct caused by the disability where there is violence or the threat of violence. And just briefly, I'm going to go over the facts. Ms. Wells was a clerk for the Superior Court. She was assigned to the sheriff's office. She didn't know at this date that she was having an onset of a bipolar episode, but she got angry because she was left outside to wait. She swore. She said something about adding the people who made her wait to what she called her kill bill list. The Superior Court let her stay, but the sheriff's office let her stay, but they asked that she never be sent back again. Shortly thereafter, her doctor put her out. While she was out, she wrote all sorts of threatening emails to friends and coworkers, threatening voicemails. And when she was released to return to work, the county did an investigation and put her on the investigatory leave and eventually fired her for her threats of violence. And as we said, the California courts have said, in the instance of violence or threats of violence, you can discipline the conduct, even though, as here, it was caused by her disability, bipolar disease. The court still left open the issue of whether, in other circumstances where the conduct was caused by the disability, whether in California it would be permissible to discipline for that conduct caused by the disability. So that's still an open question in California.
Yeah. So now we're going to shift gears and talk about 3 interesting police cases. We've been sort of calling them the trilogy, although I don't know if anybody else refers to them that way. The oldest one is I'm not sure how to pronounce it, but we've been saying Culette. And there's actually a typo on the slide. There should be a second L there. But it's Culette versus City of Los Angeles. And this is a case, it's interesting. It was a police officer, and he was injured on the job. He had a workers' comp case, and he was released to return to work, but with a finding of 100% disabled. And they put him back to work, and they put him in a desk job, a light-duty position. And then somehow somebody realized, wait a minute, he's got this workers' comp rating of 100% disabled, and they reacted to that without, I think, giving it sufficient thought, and they just sent him home. And they said, you know, you're 100% disabled, you can't be a police officer, and they ultimately terminated him. So he sued, and the court found that it had been disability discrimination. He had been terminated because of his disability. They found that the employer failed to engage in the interactive process, and that they failed to otherwise accommodate his disability. So the thing that's interesting is the court agreed that he was unable to perform the essential functions of the police officer position because of his disability. He was limited. But the thing that was the problem for the employer is that the court said what you need to look at is not whether he's able to do the police officer job he used to do, but the position to which he was requesting reassignment. He wanted that light duty position to be a permanent assignment. Now normally, and this is something that Leslie and I say all the time, is we're not required to make a job for somebody as a reasonable accommodation, and we're not required to have a temporary position be offered on a permanent basis. But here, the employer had a long-standing practice of letting people who were disabled, these disabled police officers, letting them return and permanently stay in these light-duty positions. And it wasn't, the evidence was like just huge. Apparently they had about 8,500 officers, about 3,000 of them were disabled, and 250 of those 3,000 disabled officers had been on permanent light-duty assignments for a very long time. And they were all people who could not perform the type of field work or other essential functions of the police officer position that Culette was not able to handle. So they found that, you know, he was summarily dismissed on that finding that he was 100% disabled without exploring whether, and he could have done the permanent light-duty assignment that these other officers were allowed to do. So the employer at that point should have engaged, there was a permanent light-duty assignment available, so they should have put him in that. But if they weren't going to do that, they should have at least engaged in the interactive process to find out what his limitations were and if there was an alternative position that he could do. I think that would have led them back to the permanent light-duty assignment. But this is one where the employer's own practices came back to haunt them. And so you really have to look at that. And I think sometimes people or different units have been, maybe a favorite employee has come back disabled, and they've decided to permanently let someone have a light-duty assignment. Well, when you have another person that is in the same situation, you can't treat them differently. So you need to be careful about the kind of practices you establish. But one lesson that I think they learned their lesson, and Leslie and I often advise that you can, however, change your practices going forward, and you can institute a new policy. You need to give notice to the employee, and you need to be consistent once you do implement the new policy. But at the point that this Culette case was litigated, they unfortunately had this record that they had to live with, and the court said there's no good reason why you didn't let him permanently stay in that light-duty position.
Right, but the case also noticed that under Chief Gates, the Los Angeles PD did change its policy and got rid of permanent light duty.
Right, and actually, I think both the next two cases were litigated after that new change in policy. So Louis versus City and County of San Francisco, and I think there was a change statewide. I'm not that familiar with
I think
police.
this was only, it was local, it was unique to Los Angeles, at least in that case.
Well, both the other cases talk about how they implemented a change where there used to be, they were no longer offering permanent light duty to people with injuries that were post-2004. If your injury was after 2004, you could come back and work in a light duty position for 365 days, but after that, you had to return to full duty or request a disability accommodation or take disability retirement or seek unpaid leave or take sick leave or a family medical leave. But the idea was you had a year, and they were establishing a new practice going forward of not having permanent light duty. So Louis was a situation. He had a heart attack. He was a police officer. He wanted an administrative position that would not require him to perform a lot of the strenuous physical duties associated with being a police officer. And the employer said no, anybody in a police officer position, because he wanted an administrative officer, but an administrative position that was still a police officer, because he wanted to maintain the salary level. They said that they could not offer him that, so he opted to retire after he had been off and returned temporarily to the modified light duty. But when he hit that 365 days, they said they couldn't keep him in it beyond that. So in this situation, the department did offer to look for non-sworn peace officer positions for him, and he wasn't interested. He wanted to maximize his pension, so that's why he opted for retirement. But the key question that the case focused on is, were the essential functions that were essential to the police officer position really essential functions to the administrative police officer position that he wanted? And the court said yes, even though a police officer who was in that administrative role would rarely have to perform those more strenuous duties, it was legitimate for the employer to require that person be able to perform those functions, because they had to be able to deploy them if necessary, for example, for emergencies or mass mobilizations. And even though the person would rarely have to do those functions, it was okay for the employer to say that they were essential. So this was a case that came down in favor of the employer, and I think gives us some helpful language. So even we have some situations where maybe because there's a limited number of people that can do something, and this position has to be able to do it, we can, I think, argue that it's an essential function, even if that particular function only needs to be performed periodically. So it's a helpful case, even in the non-police context. And the last of the three cases is a 2013 case, Furtado versus State Personnel Board. Mr. Furtado was a correctional lieutenant. He worked in the Department of Corrections and Rehabilitation. And he had an off-duty injury where he injured his shoulder, his forearm, his elbow, and his hand. And he came back with injuries that made it difficult for him to do a lot of things, but in particular, he could not use what they call a side handle baton. And that was considered an essential function of his position. And this is another one where the factual, as Leslie was saying about, I forget which case, Samper, that they had done so much. This one, they really did a lot to try and figure out whether Furtado could be rehabilitated to the point where he could do the baton. He went through special training. This particular position, they had to be certified every year in their ability to use the baton. So they gave him a special course. So twice he failed the test to use the baton. And meanwhile, his own doctor was saying that there was no way he was going to be able to use the baton because of his limitations. And he was also unable to do other things. So what he wanted was to be able to work in a peace officer position, but be lifted from that obligation to be able to use the baton. And so the focus was on whether using the baton was an essential function of that position, even if he was doing something that was more administrative. And the court, the employer agreed with the court agreed with the employer that it was an essential function, even if he was primarily on a desk job at the correctional facility. All of the officers, all the police officers had to be able to disarm, subdue, and apply restraints to an inmate, and they had to be able to defend themselves against an armed inmate, because when there was an uprising or in certain situations, they had to be able to react and have that ability. And being able to use that baton was a big factor in being able to protect themselves and protect their fellow officers. So they did determine that his inability to use the baton did render him unable to perform the essential functions. So when the department had not put him in the peace officer position he wanted, what they had done was look for alternative positions, and they looked at positions that were not lateral but lower to see if they could accommodate him. So what they had done was what was called a medical demotion. They had put him in a position that was a lesser position, but only after determining that he couldn't be accommodated in his current position, and he couldn't be accommodated in any kind of lateral position. And the court said that the employer had acted appropriately in doing that. So this is another one where I think they really deferred to the employer's determination of essential functions, but the amount of evidence that this employer had put forward to demonstrate that this truly was an essential function was really considerable. I think they really developed a very, very strong record. So I think when we're cautioning people, we want to be sure that when they're saying that something's an essential function, that they're really going to be able to back it up if the case is ever litigated. Because sometimes people want to just make sort of a knee-jerk determination that something's essential, but we really want to be sure that if pressed, they would be able to mount the kind of record that the employer in Furtado had put together. So that's the trilogy of police cases that I think provides us with some helpful principles of law as we go forward. We saved some time for questions, if there are any questions. So far, no questions.
We do have the phone lines open, so if anybody has a question, feel free to chime in. And if not, we are running up against the end of the hour, so thank you everybody for joining us. Thank you, Leslie. Thank you, Stephanie. This was very interesting. And we will have the recording up on the website shortly.